Director Atkinson.
Here.
Craig Stanton. I'm sorry, Craig Parton.
Here.
Phyllis Stanton.
Here.
And then we're also going to do a roll call of the folks on the phone. So if you're on the phone, can you please announce yourself?
Michael Davis. Stan Powell, City of Los Angeles. Robert Cush.
Anybody else?
All right. Adoption of the agenda.
Second.
We have a motion and a second to adopt the agenda as printed. All those in favor?
Aye.
Aye.
Thank you. Public comment, non-agenda items. Seeing none. Special presentations, we have none. We move on to consent agenda, payment of the bills. We can do all of them together or separately, whatever your pleasure is.
I'll move approval of the consent calendar.
Motion to approve the consent calendar.
Second.
With a second, all those in favor?
Aye.
Aye.
Good. Advisory committee report. With my namesake.
Good morning. If you can hear it, if I can talk long enough to get this report out. Dennis Lamro with the advisory committee. We did include a memo in the board's packet. I don't know if you want to talk about each of those items as they come up on your agenda, or if you have any questions at this point that I can try to answer.
Any questions for him?
In your infamous wisdom, the memo speaks for itself. So.
I'll take that. I'll take that.
Thanks, Dennis.
Thank you.
Action items, 9A, consideration of possible action on the water master jurisdiction over parcels straddling basin boundaries. General Counsel's memorandum dated February 6th.
Yes, Chairman, we were asked to review the issue of basin boundaries. This came up in the context of an inquiry from someone who had a well on property that straddled the boundary. And this Phyllis has much more of a historical background. Apparently this issue has been before the board, or it's been teed up to the board on numerous occasions, and wanted a legal opinion on this. We reviewed the prior court orders from 2007, the statement of decision in phase 3 of the trial, and have concluded in the memo that the court assumed some hydrologic connectivity between all the parcels that are within the adjudicated basin boundary. And the court was rather exacting about what that boundary was. And if we're going to exercise jurisdiction on a well outside of the adjudicated area, the burden is on us as a water master group to establish the hydrologic connectivity of that well to the adjudicated area. So the memo indicates that, also indicates that when applications are made and there's an issue whether there's connectivity between the well that's outside the adjudicated area and the adjudicated basin area, that can be handled on a case-by-case basis, but the burden is on the water master and the water master engineer to prove that connectivity. Otherwise, the argument is that well and its production is outside the jurisdiction of this water master, and we'd have to get court approval to expand that jurisdiction. So that is the memo. I want to mention an immediate reaction that people have to this, which I got from a small pumper yesterday. Well, my client, this person said, has a well 200 feet on the other side of the boundary. The client has a parcel that straddles the basin boundary. Why don't he, what is the prevention of having him go and drill a well immediately outside the adjudicated area, close down his well in the adjudicated area, and then you'd have no jurisdiction? I said he can do that, but just remember, that's going to be on the radar of the water master engineer, and you better have an expert opinion in your back pocket that there's no hydrologic connectivity between where the new well is and the adjudicated area. Because simply drilling a well on the other side of the line isn't a safeguard to you. It's a jurisdictional line, but the water master engineer retains the flexibility to make inquiry on a case-by-case basis. So with that, barring questions, comments, we'd move that the board would approve this. The advisory committee had some questions about it that I wanted to address. They wanted to know whether or how the Mojave adjudication addresses this. I didn't find anything in the Mojave adjudication that addresses the issue directly. The DWR, specific DWR boundary was not an issue as it is in our situation where the court has specifically referred to DWR's Bulletin 118 boundary. The question was asked by the advisory committee whether there's a list of parcels that straddle the basin boundary. There is not, according to Phyllis, but it wouldn't be hard to generate that list. I have a partial list of some of the affected properties, but not a complete list, but I think Phyllis can comment whether we could assemble that list, I think, pretty rapidly. Is this covered? The next question was, is this covered in the rules and regulations, the basin boundaries issue? It is not. Then they wanted to know whether there could be a process adopted to consider the location of a well every time there's a new production application or replacement well application. And I think, Phyllis, you can comment on this, but I think this is something that we do already. Is that right?
Correct.
So those were the questions of the advisory committee, and with that, I'll take any questions.
Yeah, and I have a question with regards to the size of the well, for example. You know, I know there's a big difference between, say, someone having 300 acres or 500 acres that may go into production with a well just outside of the boundary as opposed to a single-family residence or some other types of, you know, smaller production. Is there any differentiation with regards to the actual well size of production and potential impact on the
That's
groundwater
really
basin?
Phyllis' question as to what would be taken into consideration to prove hydrologic connectivity.
Okay.
Phyllis, you have any comments on that? Because it's really not covered in the judgment or in the court's orders.
Sure. So, you know, all we're trying to do with this process is to make sure that we're not inadvertently pulling water from the basin with an unauthorized well. And if the well is a single-family household well and the Cone of Depression would not substantially pull water back from the basin, then that would probably be a de minimis situation. But we anticipate that we would look at these on a case-by-case basis as they come up. We're not going to try to generate lists of wells that are close to the basin boundary but outside of it. I don't think that's particularly a productive exercise to go through, and I think it'd be very difficult and time-consuming to do it. But on a case-by-case basis, as it comes up, I think it's something that we can just simply look at. And I think in some cases it will be a very easy, quick review of, you know, there's no harm to the basin associated with the depletion of storage from that well, or there might be, or there is. And then we can just recommend, you know, steps appropriate to whatever circumstances that allows. I was concerned that we would never know if someone was drilling a well just outside of the boundary and close to it, but staff has done some investigation on that and has determined that the counties are sending us all well applications, even those sort of close to the boundary. So I think we're always going to be able to monitor the situation, and staff will be able to know whether or not a new well is being proposed that could put certain areas of the basin in harm.
So, just a follow-up question. So if, I'm particularly interested in the small well, I mean, I think the larger production type wells, it makes perfect sense, but is it the intention then for the rules and regulations to require someone who's drilling a small residential well that's outside of the adjudication boundary to go through our approval process? Or is it intended to take a cursory look at that and determine whether there's a potential impact and then request that? I don't know how we're making that determination from a procedural point of view.
Yeah, I think the procedural part needs to be, and Phyllis can comment on how that's going to be worked out. I can tell you from the legal perspective, we don't have jurisdiction over it.
Okay.
From the outset. So whatever we do, the burden is on us to establish that there's connectivity between that well and the adjudicated area. Phyllis, you have any comments about the procedural application aspect to drill down on this?
No, I haven't thought through it in detail yet. This sort of just came up, and staff may have some ideas about what they've seen so far with respect to the applications for those that are close to the adjudication boundary. But I obviously understand that we have no jurisdiction, so it is not our intent to go after, so to speak, wells being drilled outside of the basin boundary. It's just a matter of whether or not, at a cursory view, we feel like that there's some potential for depletion of storage from the groundwater basin as a result of that.
Okay, good enough. Thanks.
I've got another question. Assuming somebody picks a location and wants to drill a couple of big wells that are going to pump a lot of water, then what you're saying, Mr. Parton, is that it would be, the burden would be on us to go after them and say, hey, you're damaging the basin.
Yes, if they're drilled outside the adjudicated area.
But that's after hundreds and hundreds of thousands of dollars have been spent by this corporation or individual. I guess I'm wondering if we should have some kind of a memo to the county that we be notified as a courtesy if it's within so many feet, so we could talk to the people that want to drill these wells, because it would be a tragedy to drill 2 or 3 wells and then have us shut them down.
Yeah.
And I know we don't have the jurisdiction, but maybe a courtesy agreement. I don't know. I just think it could break somebody that
Yeah,
did
yeah.
that.
You'd think that people, before they did that, would get a professional opinion that there isn't hydrologic connectivity in order to establish that to the water master engineer.
Well, and let me just add one quick thing here. So it seems clear to me that the county is letting us know if there is a well that's that close to the adjudication area. When we first worked with the county, we provided them a map of the adjudication area, and I think that what's happening now, and this is to be confirmed with staff and with the county, but staff has reported that they are getting notices from the county for wells that are outside of that boundary but close to it. So I believe that's already happening now, and that will give us the opportunity to just quickly look at it, and I think we'll be able to make a quick determination as to whether or not that would be an issue. And if it wouldn't be an issue, then they, as Craig says, we would have no jurisdiction over it, and they would just simply move on and drill their well.
Just one question for staff. Do we get the same type of cooperation from both counties, Kern and Los Angeles?
Yes.
Okay, great.
So am I interpreting that since we don't have jurisdiction, there's nothing for us to do?
It's not, I didn't catch the last part. Since we don't have.
There's nothing for us to do since we don't have jurisdiction, so we don't need to have any kind of votes.
Other than approve the memo as a position of the board on the subject.
In essence, we're endorsing this policy.
That's right.
Correct.
Okay, we have a motion?
In the absence of a resolution or anything, if we're making the motion, I'm not sure exactly what that wording should be, except to accept your recommendation. Would that become part of rules and regulations?
I would recommend that it become part of the packet of rules and regulations, so it's clear guidance for going forward on the topic. And if the board has a resolution for next month, in essence, can understand that there's tacit approval of the memo and we want a resolution to approve it formally with language worked out, I'm happy to do that.
Dennis' question is, does it need to go back to advisory? I don't know, Dennis, I think advisory's taken a position on it, and I'm not, I want to put words in mouth.
Yeah, we've talked about this subject at 2 different meetings now. We've presented all the questions and ideas that came up in the memo. It sounds like they're being addressed.
Great. And it's my understanding too that there'll be another bite at the apple with this once the rules and regulations are drafted in final form. Everybody will be able to review that too. And maybe
The full packet is
yeah,
going to come before the board.
Yeah, right. Okay. I'm going to make a motion here. I'll move that that we accept and approve the memorandum provided by our General Counsel, Craig Parton, February 6, 2019, with regards to the water jurisdictions over parcel, straddling, basin boundaries, and that the policies contained and recommendations contained within the memo be included in the final rules and regulations.
We have a motion, we have a second? Second. All those in favor?
Aye.
Next item, 9B, small pumper qualifying and monitor well applications. 52, page 52.
Good morning, I can take this, start this item off.
Yes.
So, new to the information provided at the direction of Director Henry is on page 52 of the table that shows the number of small pumpers per Exhibit C in the judgment, and then also in section 5.1.3 of the judgment, there's a reference to 3,172. And then, as you can see, to date, we have approved 54 small pumpers. So that kind of gives you an idea of where we're at. I think that question came up in the past. And then under this item, staff is recommending that the board approve resolution 19-03, approving Exhibit A, which is a list of small pumpers. It's in addition to 2 monitoring wells, Exhibit A, and for now, poll APN number 3264-015-001. There's some additional research that needs to be done on that particular small pumper qualifying thing.
Repeat that number, please.
Page number, please.
It's on page 55.
3264?
3264-015-001. We're recommending that we modify Exhibit A and remove that from this resolution.
Matt, could you do me a favor? Could you qualify or define the difference between the known small pumpers on Exhibit C as 4292 and the known small pumpers on section 5.13, 3172? What's the difference?
So Exhibit C, and Craig and Phyllis can correct me if I'm wrong here, but Exhibit C actually lists a number of parties. There's 4,292 individuals listed on that.
Okay.
And then under section 5.1.3 of the judgment, it doesn't list parties. It has a reference to an acre-foot quantity.
Yeah, to be specific, actually 5.1.3 talks about small pumper parcels.
Oh, there you go.
3,172 and an average pumping of 1.2 acre-feet a year to get to 3806 as the amount of pumping by the small pumper class that was identified in the judgment.
So Matt, because of my short memory, because of my old age, could you put in parentheses on that report in the future? Just parcels?
Oh, okay.
That would help.
All right.
All right.
Sounds good.
Thank you for doing that, by the way.
Oh, yeah.
No,
That's really
that's
helpful.
a nice,
Thank you.
you can see it.
Or whoever did it.
Yeah, Patty and Angel do all the work.
All right. Great, thank you. Thank you.
Okay, we have a resolution to approve these, except for 3264-15-1. We're going to deal with that later time.
Yes, that'll most likely be brought back at the next meeting if it qualifies.
Okay.
Mr. Chairman, I move the approval of resolution number R19-03 with the exception of withdrawing the applications that stated 3264-015-001.
We have a motion to approve 1903. Second? All those in favor?
Aye.
So we're going to do C, now that guy's going to C?
Yes.
Okay.
All right. Item number C, which is well applications revised. You recall at the last board meeting, maybe it was only before, we adopted a fee schedule for processing various applications. And our previous forms had actual dollar amounts on the forms. So we need to go through and remove the dollar amount and simply reference the fee schedule that we approved. So including in your board packet are the various forms. So we'll go through them one by one. First one on page 83 is new point of extraction application. You can see the proposed red line shows the changes that we're proposing. And simply, as I mentioned, removing the fee amount and referencing the fee schedule that's posted on the website. Same thing on page 85, which is a new production application, and cleaning up the language there. In addition to that one on page 86, for new production application, Phyllis recommended that we add the footnote number 3 there that references section 3.5.22 in the judgment under the Willis class. So that's to make it perfectly clear what they're agreeing to on that form. Page 87 is the replacement well application. Simply modifying the fee schedule or removing the dollar amount. And then on page 88, there's a note under the signature section that states, if this well is a monitoring well, I agree to provide the water master with publicly available monitoring data. And then moving on to page 89, small pumper.
Can I just mention, Matt, that page 88 also deletes the engineer's approval and modifies that to have staff approval.
Thank you, Craig. I think that was discussed at the last meeting as well. And moving on to page 91, we have the transfer request form, cleaning up the fee, and then there's a new question added there that says which party will be paying annual administrative assessments for the transfer of water. Make sure it's perfectly clear, once the transfer is approved, who gets the invoices for the administrative assessments. That's all I have unless Craig or Phyllis have anything to add.
I looked at these particularly with the eye of the two applications that are amended to have staff approval instead of the water master engineer to see if that is consistent with the judgment. And I think it is. The two forms that are being amended are the small pumper qualifying documentation form on page 8990 and the replacement well application, which are really administrative forms. Phyllis will continue to need to approve pursuant to the terms of the judgment the new production application and the new point of extraction application, which takes engineering expertise. So I've looked at these from the eye of whether these are consistent with the judgment, these forms and the amendments are, in my view.
So at what point does the applicant know what his fees are?
When he gets this form, and if the form references to go look at the fee schedule on the website, they can go on the website and see what the fees are.
You can also call staff.
You can also get the fee schedule as they pick up the form. They do it that way too. If you're old school.
Yes.
I guess my question then is, why are we taking it off of the form up front saying this is what the fee is without going to the website or all these other places?
Because we don't want to have to bring back the form every time we modify the fee schedule. This way the form can stay the form, and from time to time, if we need to update the fee schedule, we can simply update the fee schedule.
Is this like an ordinance, this is the first reading, or we can move forward on this?
You can move forward on it.
Any other questions by the board? Entertain a motion.
I'll move for approval of the new form applications.
I'll second that.
We have a motion and a second. All those in favor?
Aye.
E, storage agreement rules and regs.
So if you recall, several months ago, maybe more than several, we were talking about storage agreements. And then it kind of fizzled out. It got dropped off the radar. At the time, we were waiting for comments from various parties, legal counsel. So we wanted to put this on the agenda. It was on the advisory committee agenda as well, to kind of bring it to the forefront, get talking about it again. And since then, we did receive comments last week from one of the parties that we were waiting on. So we do have comments now on the storage agreement forms and application, rules and regulations. So that's been provided to Craig and Phyllis, so they're going to start reviewing that, and we'll get it back on the agenda and start circulating the draft. So we don't have any action today, it's just bringing it to everybody's attention for discussion.
Thanks. Meter compliance.
So I can start this off, and then Craig can take it over regarding the proposed letters. So if you look at page 99 of your board packet, simple little table showing the various parties. We got broken down by Exhibit 4, Exhibit 3, other parties, and then unauthorized pumpers. So there's a list there of total number of possible wells for each of those categories, and the number of documentations submitted for each of those areas, and you can see the percentages on the far right. And then following that table is the detail, which the information is kind of focused on Exhibit 4 parties, still working on the public water supplier documentation, but this list kind of the status of meter compliance for each of the parties. And then maybe turn it over to Craig, and he can talk about the 3 different categories that we have regarding the proposed non-compliance letters.
Yeah, this was part of our discussion last month. We have 3 categories: those that have failed to install meters and have not been responsive in any way. Second category, those that have been working with the water master cooperatively to get meters installed. And third, those that have actually installed meters just haven't gotten us the documentation. We think that each of those is in a different level and ought to get a different response from the Water Master Board. You directed that I do a draft letter. It's been circulated to the advisory committee, and I've taken their comments to heart. They basically said, can you impose stiffer penalties than what you're doing with the letter? But the memo points out that the enforcement of this is something that's going to be costly, that we want to try to avoid. And we first ought to do a letter that identifies the person's level of non-compliance, whether they're in category 1, 2, or 3. Second, gives them a timeline for response to either getting the meter installed, getting the documentation to the water master. And third, what happens if they don't cooperate. That is where the penalty issue is discussed in the respective letters. So this is the effort that we thought was appropriate, that the memo foreshadowed, that there would be some outreach to the people in each of these 3 categories. Staff has done a good job in trying to identify who those people are in each category, and the letters are ready to go out. I think Patty said this afternoon if the board approves this approach with the compliance letters.
So on page 100, those letters haven't gone out yet, but they're ready to go out.
That's great.
Same thing with 101. They get letter 2. So do you have gold stars for exhibit 4 completed? It's nice to see quite a few people.
The sample letters, by the way, start at page 105. There's 3 of them, largely similar, but there's some different language for each one. Page 105 is the, and 106 is the draft letter for those that have not complied at all. Following that is the letter for those that are cooperating with the water master. And following that, on page 109, 110, is those that have installed meters but haven't gotten us the documentation. We think is in a different category of lack of compliance.
Reading the letters, I think they're very appropriate and clear. I have no problem with that. You know, the list of non-compliance is frightening. Probably a dumb question to ask, but is there any kind of ballpark number of what it costs to send one of these letters in your time, staff time?
I think that the work is done now. Now it's just a matter of identifying the people and sending the letters and following up with non-compliance, what we're going to do next in terms of enforcement.
Mr. Chairman, I would move to approve the draft letters as letters to go out to non-complying pumpers.
We have a motion to approve these letters and get them sent out. Do I have a second? Do I have a second? All those in favor?
Aye.
Discussion on modifying the frequency of the Water Master Board meetings.
I believe this item was requested by Director Keeble, so if you'd like to start it off.
Yes, I made the point that we really rely on the staff to give us the input for us to make the decision of how often do we really need these. And so I would yield to the staff to, you know, how often, what are the issues, what problems, what, other than saving a little bit of money, what are the issues that might come up with this kind of thing? And I'm thinking in terms of, should there be an emergency, what is the recommendation of who, staff, board members could, and the procedure for calling a special meeting to deal with those issues, emergency issues?
Well, back to the first question, what kind of problems would that cause? As I say, meet every other month. As you know, right now, the board approves all payment of bills, as well as approves all the well application forms on a monthly basis. So one downside, unless we look at the policies and procedures, it gives some authority to staff to process those types of things and then ratify them at a later board meeting. It could hang things up for a couple months as far as payment of bills. Also, if somebody's waiting for a particular application that they've submitted to be approved by the board, you know, it could be 2-3 months that they're waiting for that information if we go to meeting every other month?
Our board had a discussion about this, and the board's feeling was that until the rules and regulations are done and we have a more administrative procedure that's available, that we should, the Water Master Board should continue to meet monthly in order to address those meter water well issues. And to the extent that we can use more telecommuting kind of, we have some video conferencing equipment that's available here that we can make available for maybe some of our consultants. Phyllis is not here today. We can make use of that, help to lower the costs for the travel back and forth. And the boards authorize us to make sure we have the software and the wherewithal to be able to provide that so that we can actually see Phyllis talk to us at the same time as from her office, as opposed to making the flights down. You know, on some occasions, obviously there'll be some times when she'll need to come down here. So that was kind of the our board's opinion.
And I would concur with that. And what I'd like to see us, we change the meetings, I'd like us to go to a 6-week schedule rather than an 8-week schedule as a trial basis before we jump to 8-week. That would be my suggestion. But I'd like to stay at monthly till we get away.
I think I would agree that there's some issues that we need to get resolved before we would go to these, you know, whether 2 or 6, 6 weeks or 8 weeks. I think if we look at the routine agenda, the invoices are very, I guess, routine for the most part. I would trust the staff that as long as they're routine things that, excuse me, they, those invoices be paid on a timely basis with ratification at our next regular meeting. I think we could anticipate some of these things also. So, but I agree with Dwayne and John that right now we need to be dealing with rules and regulations, some of these other forms to get our feet on the ground and proceed from there. But in the meantime, we need to know what the issues might be, and we can be looking at those and how we might resolve them down the line.
Based on our salaries, we should just have an annual meeting.
Whose salary?
Exactly.
Richard, do you have anything? No, I think I agree with Dwayne and with Matt in terms of letting it, go monthly until we get a better, process, and we have rules and regs are in a better place, and we have more administrative guidance in terms of paying bills and stuff like that, and well applications.
So by consensus, we're going to continue on a monthly meeting until we get a few more.
Mr. Chairman, is there any comments from the audience, whether these meetings are?
Yeah, we had our meeting last night, and it was just that with all the new well applications coming up, wouldn't be fair to them to have to wait 60 days.
Anybody else? All right. Administrators report.
I don't have anything to report unless Peter does.
I don't either.
We're good.
Engineers report, Phyllis.
You might be muted, Phyllis.
That's always a problem with calls. Where's my mute? How do I get that back on my screen?
AVEC has filed a petition for Supreme Court review of the decision on the attorney's fees. PLM is the only appeal that we are actively interested in, at least I've been directed by the board to be involved in, since they're appealing the motion determination by Judge Comer that we obtained. Their opening brief is due in May. We have a reply 5 brief due in September, and then they have another brief due in November, so hopefully that'll be teed up in writing this year. The update on pumpers, people producing groundwater outside the terms of the judgment, I just mentioned a couple of things, just updates. One is Long Valley. We've been working cooperatively with Long Valley's council on their situation, and there should be some more discussion with the board on that, perhaps in the next month. But it's been very cooperative discussion about how they might take care of their replacement water assessment that is a result of their motion before the court. Update on Joshua Memorial Park. All I can say is I'm in discussions with their council. I expect, and one of their lawyers is on the phone, I expect potentially in the next month or two to have direction to the board about how to deal with Joshua Memorial Park, who is not a party to the judgment, and we're talking about a motion for them to intervene. So there'll be more detail on that. Again, very cooperative, very productive discussions with both of them. Rosamond and Desert Breeze, to remind you, Desert Breeze is the mobile home park that is, because of compliance issues with water quality, Rosamond has been in the position of taking over the supply obligations, but wanted to get a transfer from Desert Breeze of their production right. Because Desert Breeze is a non-stipulating party, the judgment says they can't be involved in transfers, but we've been in discussions with Rosamond, not particularly in the last month, but hope to in this coming month, that there's a way to get beyond that, that this is really not a transfer for the benefit of Desert Breeze. It's a requirement that they do this transfer. We'd like to get that in front of the board, hopefully next month.
Craig,
Yeah.
the money we're spending on that, is that going to get reimbursed by all these parties?
The money, I have spent very little time on Rosamond. I've just had discussions with one of their principals, but there has not been any documentation to review. I haven't raised that with them. We'll have to see what happens in the next month if there's substantial legal work involved in that. I mean, it's in their court to tee that up. The memo on the civil engineer stamp, that's at page 114 of your packet. That was a request to the board whether there might be an opportunity to save some money on engineer stamps. Remember, there's a two-step process for new production applications. In the judgment, one is that they submit a water conservation plan and a material injury analysis. That's the applicant's responsibility to do that. Once that is completed and an engineer stamp is obtained for those two activities, it then goes to the water master engineer. The memo concludes that that's a separate analysis, that we should not and cannot, under the terms of the judgment, have Phyllis doing all of those. And it wouldn't save any money for the applicant anyway, because there's a provision to recoup the fees that the water master engineer incurs. So it's not a cost-saving issue, and in fact is not allowed by the judgment. One civil engineer can do both of those tasks for the applicant, the water conservation plan and the initial material injury analysis. That can be done by one civil engineer, but then the process has to be approved by Phyllis. And there's logic to that, because she hasn't seen any of the application underlying materials. She'll have the benefit of seeing the water conservation plan and the material injury analysis done by a separate engineering firm, and then can make her material injury determination as a result of that. So the bottom line of it is, while the water master engineer can determine that the new production is de minimis and waive replacement water assessment, that only occurs after Phyllis has done the material injury analysis. So there's really the answer to the question. There isn't a way of cutting the costs at that end for the new production applicant. We need to keep the process where They retain a civil engineer to do the water conservation plan and the initial material injury analysis, and then Phyllis, pursuant to the terms of the judgment, and I think this is all spelled out very clearly in the judgment, provides her material injury analysis. Memo didn't get any comments from the advisory committee. Phyllis has looked at it. It's been circulated for a good part of last 2-3 weeks, so any comments are welcome. But that's the conclusion.
I would like to make a comment. I certainly understand, read the memo, understand the position, the legal position with the judgment the way it's written at the present time. However, I think we need to understand the impact that that provision has on, and I'm speaking only of residential, small, insignificant pumpers, and I would like to see if there's a way in which we could make just a modification to the judgment to exempt residential type meters from some of those water conservation and maybe not harm, but certainly the water conservation requirements for just only those residential type meters, understanding that any kind of production or other type of meters need the full water conservation plan and all the things that are involved in that. But it's a fairly significant burden on someone trying to build a single-family residential unit for those very limited impacts that they may have with regards to the basin.
We could certainly request the court a modification of the judgment, but there'd be costs involved in that.
I understand.
So we're aware of that. The judgment sets it out pretty clearly. I haven't looked at it in terms of what it would take to get a modification from the court, but if the board wants to direct that investigation, I'm happy to do it.
All I'm saying is I think it'd be best to discuss this matter when you have a full board of regular members and not alternate members. But I do know that for those individuals, this is just a burden that I don't think is particularly necessary for small residential type meters.
Yeah,
But to be clear, Dwayne, we're not talking small pumpers, we're talking those above the 3 acre-feet a year.
What I'm talking about is the small pumpers that become new production. In other words, they don't have they're just developing a lot out wherever it might be. They may be having to purchase replacement water to offset the pumping, and they still have to go through the same program. And I understand the intent was to make sure that, some large production or industrial complex or housing development or some other mechanism is using, new production, that all has to be analyzed, and that all makes sense. But I think we have thousands of these small lots out there over the next few years that may or may not develop, but it puts the ones that have tried to develop, this has been a burden that I don't think is...
amendments to the judgment, and what you might want to think about doing is cataloging all of those and submitting them to the court at the same time that you submit the rules and regulations. That's going to require a court hearing in any case, and you can probably minimize the cost at that time. So just to put that on your radar, you can start making a list of I won't call them clerical changes to the judgment, but cleanup changes to the judgment.
Yeah, that's a very good point.
Any other comments?
Okay, the last items, the memorandum on small pumper class water rights allocation is a memo done in the last month starting on page 119. I'd like to defer discussion of that because I've gotten comments in the last couple of days on it that I'd like to think through, some other potential amendments to that. As is typical, the memo goes out and then people think about it and then read it and have very helpful comments, and so I want to encourage that process. And it's not up for a vote anyway today or approval in any sense. It was just a discussion memorandum. But I would like to suggest to the board that for the next meeting, I'd be directed to give some thought to this issue of the small pumper class pumping limitations, because I think it would impact on the small pumper allocation memo. I want to think through that a little bit more clearly. I know staff has told you that there's 4,292 individuals on the known small pumper list, and yet another part of the judgment talks about 3,172 parcels. Then there's 1.2 acre feet, and is that what they get, or do they get anything? Is it a collective allocation? Those are the issues that I think we ought to discuss, and I think it's premature to discuss the memo without having the bigger picture of how the judgment talks about limitations on small pumpers as a collective. I know you want to talk about that small pumper memo, and I found it fascinating, but I think it's better to be deferred.
Probably need a PowerPoint so we can follow all.
Yeah, I think that's something we're going to consider doing next week. But with that, that's my report, Mr. Chairman.
Any other questions? Phyllis, are you back?
I never had left. Can you hear me?
Yep.
Okay, it's your.
I was just talking away to nobody here. So the quick report from me is this: for the meter compliance, I think you've heard everything that you need to hear with respect to the letters going out and the lists. If Gene Nebeker is in the audience today, I want to promise him the batch of chocolate chip cookies that I promised the first person who was in complete compliance with meter installation. And so I want to give a shout out to him. Thank you very much for doing that. And thank you so much to everyone. If you're on the completed list, I agree, you get a gold star. We've really got to get this done. So that's all I'll say about meters. I wanted to say something briefly about transfers, because the issue of how transfers could help production right owners who either accidentally or inadvertently or in an unplanned manner go over their production right for the year, and if they don't have backup water accounts, can they, instead of having to pay a replacement water assessment, provide a transfer instead, retroactively, after they've already overpumped? And from our point of view, I don't see a problem with that. It's obviously a policy decision, but just from an accounting perspective, it would be easy enough for us to track. As you know, we need to track all transfers, but we would ask that if anyone is going to use a transfer in lieu of paying a replacement water assessment for overproduction of a previous year, then we'd like to have that transfer request prior to or at the same time that the production is reported, so that we can prevent invoicing someone for a replacement water assessment when they don't intend to pay it because they're going to get a transfer, and then also to point out that that the assumption that the transfer will be approved is on the requesting party. So those are the details that I would propose to incorporate into the rules and regulations with regards to transfer, recognizing that parties have already asked about this, and I see no problem with it from my perspective, and just wanted to sort of put it on your radar that that's what might be amended in transfer rules and regulations in the future. I don't know if you have any comments on that. Okay, hearing none. Hearing none.
Is that going to have to be on the form? Was John's question.
I'm sorry, could somebody repeat that?
The question was going to be, then do we need to put that on the form somewhere? that they need to notify us at that time?
Yes, probably. That's not a bad idea. I mean, my focus, of course, was just getting the concept embedded into the rules and regulations. But sure, we could absolutely add that to the transfer form.
I will say this, Dwayne Chisholm, fellows. I would say the policy concept of having retroactive transfers to compensate for replacement water, I think is a good concept. Exactly the specifics of how it gets incorporated into the rules and regulations, I'll leave that to you to kind of recommend and figure that out. But I think from a conceptual point of view, I think we can support that.
Great. Okay, and then speaking of rules and regulations, I guess everyone is aware that the public water supplier's attorney provided us with a sort of a rules and regulations package, so to speak. And we, of course, have our working document draft that we've shared with staff and council, but haven't shared with everyone yet because it is incomplete. And so the thought process is that we would incorporate, well, it's our responsibility to take responsibility for the document, so we appreciate the help, and we would incorporate the pieces of the public water suppliers rules and regulations into our draft rules and regulations where appropriate, and then provide that draft back to council for a first look, and then that would then go to this committee that my understanding is being set up of attorneys to look at that draft and work with us on that draft prior to bringing that to the board. That is my understanding of how the board wanted the process to work, and if that is not correct, I guess I'm asking for your input now on what that process should be.
Well, I guess I wasn't here at the last meeting, so I'm not sure exactly what the intent of the board was.
Phyllis, once you get a draft, should it go back to the advisory group to comment on it, or have they already commented?
I think that the process would work better if it goes, Phyllis completes what she wants to do in terms of incorporating the public water suppliers' comments and sections of their draft. Comes to me at that point, then it's going to go to the committee at that point after I've given it a review. And that committee will, 5 lawyers will have some input, obviously, we'll get it in shape. Eventually it has to go to the advisory committee also. So there's full vetting of that document. But that'd be my recommendation. It goes from Phyllis to me to the attorneys committee, and from there to the advisory committee.
Is that too much to ask for that for next month, or is that 2 months?
That's right.
I'll leave that to Phyllis. It's probably better, Phyllis, for you to know when you think you'll get me the draft.
Yeah, I was just trying to do it all in one fell swoop to the extent that I could. We've got almost no money to get this done this year, so just trying to be as efficient as possible and trying not to put pieces out. It seems that every single board meeting, there's yet one more thing that needs to be incorporated in the rules and regulations. So I've got a long list, and I'm trying to kind of do it all in one fell swoop if possible. Maybe that isn't possible. Maybe this is something that we just start the process, and then when we're out of money, we just see how it transpires.
You can just dump it on me when you're out of money.
Okay.
Sounds like
I hear 2 months. Is what I understood in that conversation.
Yeah, I think that's best.
Okay. Anything else, Phyllis? Any questions for Phyllis? Thank you. Board members' requests for future agenda items? Do you have any? Richard?
No.
We have a couple automatic carryovers, but nothing else.
Okay. When's our next meeting date?
March 27th, Wednesday, at 10 a.m.
Any other comments from the public? Hearing and seeing none, we're adjourned.